Good morning again. We'll get started after the break, and we'll now be dealing with the courts and their audit report. And in the meantime, I need to swear the two officers in.
I swear by Almighty God that the evidence I shall give to this Honourable Legislative Assembly shall be the truth, the whole truth, and nothing but the truth. Thank you.
I swear by Almighty God that the evidence I shall give to this Honourable Legislative Assembly shall be the truth, the whole truth, and nothing but the truth.
And good morning, Ms. Bothwell, and good morning, Ms. Tiffany Ebanks.
It's Ms. Bush, who's with the Finance Centre. Ms. Ebanks is on her way, Mr. Chairman.
Oh, okay.
We had a little mix-up with the times of the summonses, but
No
she's
problem.
en route. Thank you.
No problem. We're a very friendly committee, so we'll accommodate it.
Thank you.
The way we operate is that when you ask the first question,
Yes, sir.
please identify yourself by name and title for the record, and so the listening public will get there.
Thank you, sir.
Okay. So today we have some questions, and what we normally do is make the Auditor General give a short summary so that we all get in the correct frame of mind about what we want to talk about. So I'll invite the Auditor General at this time.
Thank you, Mr. Chairman. I'll refer you to page 64 in our report for the specific detail about the qualification point on judicial administration, which relates largely to the entity not having a detailed fixed asset register until the year 2015-16. This meant that a modified audit opinion was given because we couldn't qualify the completeness, existence, accuracy or valuation of the property, plant and equipment. During the year ending 30th of June 2016, Judicial Administration moved from its main office in DMS House to Government Administration Building on Elgin Avenue. And with that move, they performed a physical verification exercise of their fixed assets in use and compiled a detailed fixed asset register with the help of an outside company. We use KPMG to audit this entity for us, and Garnet oversees and supervises that audit prior to my sign-off. So Garnet's here with me today. Clearly, we can't preempt the 16-17 audit, but everything else being equal, we do feel confident that the entity is on the way to a clean opinion. Thank you, Mr. Chairman.
Okay. I guess the first question would be, have you gotten the matters sorted out with the fixed asset register for your 16-17 accounts?
Suzanne Bothwell, Court Administrator and Chief Officer. As a point of order, Mr. Chairman, I just wish to clarify the statement made by Madam Auditor General regarding Judicial Administration's move to Elgin Avenue. Judicial Administration is not on Elgin Avenue. We remain in the center of town. And I can say that I do know, being a past employee of another entity, that Portfolio of Legal Affairs moved from DMS House to Elgin Avenue at the Government Administration Building. But I can say, however, sir, that there was a question regarding the completeness of the asset register for judicial administration, which resulted in the qualified opinion. And steps were taken in 2016 to prepare a completed asset register which was completed, I think, around June of 2016. And that register is will be used as a basis for our asset register and will certainly be updated annually to identify any changes or additions to the asset register itself.
Mr. Gonzalez.
Good morning. Just a quick question through you, Mr. Chairman. What was the process used to create the fixed asset register?
I can say that a local firm was retained by the then Chief Financial Officer who was in post. That person is no longer with the organization, and they prepared a schedule of documents identifying all of the furniture, plant, equipment of the organization, and then a separate register of the values, the current day value of the assets.
Thank you. I think it's probably be easier if I say if the CFO is en route, because I think it's more an accounting question, because what I'm looking for is the completeness of the register in terms of the process used. And I think that'd be probably best answered by the CFO. So I'll wait till the CFO come to continue with that question.
Okay, and you've addressed the surplus position being repaid back to central government in compliance with the public management and finance law.
The surplus? Sorry.
Yeah.
Oh,
The observation by the Auditor General is, in accordance with the public management and finance law, government entities are allowed to retain such part of its net operating surplus as determined by the Minister of Finance. As of June 30th, 2015, the entity had accumulated $927,327 of surplus payable on its statement of financial position. We were not provided with any evidence that the entity was explicitly granted permission to retain these surpluses in accordance with the law, obviously.
So, Mr. Chairman, I don't have any indication of the agency retaining surpluses as far as I'm aware, but I will have to perhaps do a further due diligence. As far as I'm aware, judicial administration hands over all of its surpluses. However, I will have to, in order to give you an accurate response, I will perhaps have to do a little bit more due diligence to ensure that there was no express provision by the Minister of Finance to allow judicial to keep its surpluses. As the current court administrator and chief officer, I have no indication in the future budgets of us keeping any of our surpluses.
The management response, the Auditor General says, on October the 30th, 2013, all ministers' portfolio officers were instructed by the Honourable Minister of Finance to repay to Cabinet the net accumulated surplus up to and including the year ended 30th of June 2012. Given that the entity had a net accumulated loss at June 2012 and still maintains one, notwithstanding the surplus of $214,152 in June 2016, no payment has been made. However, the entity will endeavour to consult with the Minister of Finance as is required. It has any consultation with the Minister of Finance? Have you all received any application from the court to keep this $214,152?
Mr. Chairman, our CFO has just arrived. If we could have a few minutes to just discuss with
Sure.
her the issue.
Sure.
Thank you.
Okay. Okay. So
I swear by Almighty God that the evidence I shall give to this honorable legislative assembly shall be the truth, the whole truth, and nothing but the truth.
Mr. Chairman, we're checking within the Ministry of Finance to see if such a request was made to us. I expect to get an answer fairly soon, but maybe it's possible, Mr. Chairman, that Ms. Ebanks might know.
The question we were asking is that the Auditor General raised the matter of the courts not having evidence that they were given permission by the Ministry of Finance in accordance with the Public Management and Finance Law to retain surpluses at the end of the year. And we were just asking if that had been clarified.
Tiffany Ebanks, Chief Financial Officer for Judicial Administration. Just to preface by saying that I became the Chief Financial Officer effective February 2017, and so I was not involved with the 2015-16 audits or those prior. However, I have gone over the material and will try my best to answer your questions today. In regards to the surplus, In regards to the surplus, I am not aware of any written correspondence to the FS as yet regarding whether judicial can retain that. However, I do understand that judicial administration had been carrying a deficit previously and will be submitting then to the financial secretary if they can net that surplus off against the prior deficit.
Mr. Chairman, through you, sir. One of the earlier questions we had was with regards to the fixed asset register. And what I'm looking for is completeness. I was trying to understand the process that was used in which to complete the fixed asset register.
So sorry I'm late. My summons was for 1 o'clock. So you're trying to gain some understanding regarding the
process used to complete the fixed asset register. How was it set up?
Okay, so previously, based on my understanding, there was a fixed asset register that was maintained. That was maintained by category with supporting schedules for additions and disposals relating to each financial year. In 2016, they undertook a fixed asset count, which included office equipment, computer, furniture and fittings, etc., as well as they then consolidated all of the information they had been carrying for the previous years to put together then a comprehensive fixed asset register. And that is what was produced to the auditors as at the 30th of June 2016.
So what I'm trying to get at, because I noticed the gross carrying value of the fixed asset is roughly 2.9 million. And yeah, well, before depreciation. I think it's on, excuse me from memory, so let's bear with me. On page 16, which is note 5, property and equipment. If you look in the lower part for the 30th of June 2016, you see the actual cost is roughly 2.889 million, which is just under 2.9 million.
Right.
And then there's depreciation. So what I'm trying to figure out, or in particular, what I want to get comfort level on, You look at the computer, for example, computer hardware and software. When assets aren't being tracked, then there's a possibility that things can slip through the crack. And then understanding the sensitivity and of the nature of what is done at the judicial is that how comfortable or what comfort level can we have that just about every single computer, laptop, or whatever was properly accounted for. No, vehicles are straightforward. I mean, someone is hard for someone to go take a car. But a computer that may probably have information on it, what I'm looking for is that level of completeness. So what I was more looking for in the answer is that, you know what, we went back, we look at all the invoices where we spent X, Y, Z, and we made sure that was actually accounted for. So it was more that I was looking for in terms of we spent this, and this is there, because these things, the amount of units, it's very easy for one to go missing. Yes, it'd be immaterial, but I'm more interested in the information that may have been on a computer per se, as opposed to just one computer out of 100 missing. That could still have sensitive information on it. So what I'm looking for is just a certain amount of comfort level that it just wasn't a book exercise or a financial exercise to complete it, but rather areas where confidential information would have been given particular priority with regards to making sure every single thing is accounted for.
Suzanne Bothwell, Chief Officer. With respect to the statements that you just made, sir, each item that has been identified for the fixed asset register has a code and a label. They went through that process. In addition to that, the Judicial Administration has its own IT department separated from computer services, and those staff members manage the computer equipment, the life of that equipment, and they have their own information on that. If a piece of equipment went missing, I will not say that it's highly unlikely that staff will not notice it's missing, because each person in the organization, most of them have their own station. But most importantly, there's no data that is stored on the computer itself. The way government data is stored are through servers, and so civil servants are prohibited from storing any data on the hard drive of the desktop or the computer itself. You must store your data on the server, which means that a computer can die, it can be switched out, and the data is not lost, it's not affected. That data is secured elsewhere. So in order for us to, certainly there is a way for us to track the equipment in the plant. And of course, the government has its own methods by which we are allowed to dispose of equipment. Separately, the court, in terms of the security of, I think the biggest risk of security for the court is cyber intrusion, as opposed to theft of the actual physical equipment. But I can say that the court is heavily surveillanced, interior and exterior, and we do have an alarm system. So unless a theft occurs outside of working hours or outside of when the securities leave the premises, there should be some indication that there has been some intrusion into the organization. But we do have mechanisms, I think, through the asset register to identify the equipment and the furniture, et cetera, that's there. We are undergoing processes internally, particularly for this budget year, to ensure that we can make this a living document per se, so that we can continue to identify the assets and if there are additions, and particularly in the future if there are needs for disposals, how we go about that process. I don't know if that assists you in any way.
Well, it's a good answer, I will say that much, but when you consider that the one government department that's charged with security has lost guns, I've lost drugs, and I've lost 1.3 terabytes of information, which is the police. I think from that standpoint, and I don't think there's any building that would have more secure personnel than the police department. The reality of it is we do have these issues. And the thing about it is, when you mention that you now have your own IT department, the next thing that brings up for me then is segregation of duties, where the person who ordered the goods, the person who received the goods, and the person who's paying for the goods being separate. In most entities, you'll find that the person ordered and receiving it is the same entity, while there may be a finance department paying for it. Now, I know of one government department already where in IT, where they were already fraud committed, where basically the computers that were being ordered wasn't even coming online. So, I mean, it didn't even make it that far. You know what I mean? So those are the kind of things that we're looking for. So even in terms of data protection, I mean, it doesn't take anything for someone to file savers and save to a hard drive or whatever. I mean, there are easier ways around this. So, I mean, yes. So the question for me then in all of this is, what are the checks and balances within the system? Where is there an IT audit that is done to make sure that no one is saving on the C drive or computer, which are pretty much built in, and pretty much, if so, how frequently is this done, and also in terms of inventory, how much is it checked? I mean, who checks the IT guys? Is pretty much what I'm also trying to get to.
And certainly, Sir Suzanne Bothwell, Court Administrator. Okay, thank you. Certainly justified questions. I can say that as a fairly long-serving civil servant, there are certain, I think, IT questions that perhaps needs to be looked at by the government at large regarding the consistency of practice across whether it's central government or statutory authorities regarding the security of data, equipment, etc., procurement, etc. I can say that since I have taken up office, I have worked, and my team are working very closely with the Computer Services Department to ensure that we have some level of harmonized practice. With respect to removing information through the USB drive or whatever it is on the computer, I am not aware of government having a single protocol for that, but I can say within the courts that our systems are locked down. Employees are not actually allowed to save information or pull information from the system, save for very specific categories of persons, and it can be traced as to who can do that. So that is something that we have locked down in our system. I think it's a USB port. Furthermore, most of the court information is driven through a database. So our system works, most of our staff work through a database. And so the information that's generally inputted, about 80 or 90% of the information is inputted into the database itself and stored there, which is then onto a separate server. But I do take your point, sir. These are things I think that each government entity is in a stage of transition or advancement, and certainly judicial administration is cognizant of the risks that you have identified, because technically we are the only entity that in the entire government that houses the information that we have. And so certainly the security and confidentiality of that information is of extremely high priority to us.
Mr. Chairman, through you to Ms. Banks. My question is on the depreciation policy for textbooks. The Auditor General's office identified an issue with the depreciation policy for textbooks. The entity is using 10 years to, or your entity is using 10 years to depreciate these books. The entity could not provide an assessment of the textbooks on hand as of 30th June 2016. And as a result, the Auditor General's office could not factually verify whether any adjustments would be made to the financial statements. A high-level overview based on assumptions indicated that it is not likely that a material misstatement would exist. However, with frequent purchase of these assets over time, a situation could occur that would result in asset balances being materially misstated. My question is whether an analysis has been done to determine the quantity of textbooks that are currently on hand, and if the depreciation policy has been developed to reflect a more realistic method of depreciation for these assets.
Okay, through you, Mr. Chair. Thank you for the question. In regards to the depreciation policy in 2016, there was a review of it to determine whether all the books could, whether 10 years was reasonable. And there is a librarian for judicial administration that reviews and that sort of thing, I guess I should say, is responsible for the library, the book coming in and out. In consultation with her, the librarian stated that the majority of the books that judicial holds, 10 years would be reasonable. There are aspects of it in terms of other entities for which I'm responsible for. When we reviewed, some of those depreciation methods had to be changed, and that's being reflected in 16, 17 and those other entities. But in consultation with the librarian, the depreciation method of 10 years continues to be reasonable in terms of the books that are held by judicial administration. And that librarian is responsible for keeping track of those books that go in and out of there. As far as I know from the court administrator, she's advised that that room is under lock and key. There is also surveillance in there as well. So those are monitored then in terms of the actual assets on hand.
Mr. Chairman. Mr. Austin. Mr. Chairman, through you, this question is directed at the Chief Financial Officer, who I believe may have indirectly... Is this on the book, the textbook thing? Pardon me? No, sir. Okay, I just have one follow-up question. When you get a new edition, do you write the book off completely at the time of getting the new edition, or you still keep it in stock and have a value for it?
So through you, Mr. Chair, those additions then are added to the fixed asset register. It's at the point after the 10 years, once it's deemed that those books then have been fully depreciated, that they will then be removed.
Sorry, Mr. Austin, go ahead.
Actually, just one textbook question before you goes. I noticed the other assets. I'm assuming that textbooks are on the other assets, and that's roughly almost $1.9 million worth of textbooks, or is there other things included in it?
Through you, Mr. Chair, on page 17 of the report, it gives the cost of library books as $809,000. The net book value right now that's being carried as at 16 was $185,000.
Yeah, I'm assuming that most of those would have been like prior case studies, so would have been like precedent. So
Research, books, reference.
law is a law, so I mean I'm assuming it would still be valid. So I don't think 10 years is probably unrealistic, realistically, if that's what it's being used for.
Yes, sir. They fall into broadly two or three categories of books. You have the law reports. So, for example, the Cayman Islands has its own law reports. Those are the published cases at various levels of courts from different jurisdictions. And then there are generally textbooks on specific subject matters which are periodically updated by the authors. But even though you get the updated text, it does not mean that the original text is of no use. Sometimes in the profession you have to go back to the beginning, and sometimes that is helpful. So certainly, but at some stage you will see that they do transition out and are no longer useful. And then there are journals, which are basically periodicals on specific subject areas dealing with current areas of the law. And those appear, I don't think they will throw those away because each journal is different unless they're consolidated.
Thank you. Mr. Chairman, through you, again, a question to the Chief Financial Officer relevant to the expense trend analysis.
Whilst I believe some of these questions have been answered indirectly through the previous questions, I'd like the opportunity to just address it directly to the Chief Financial Officer. According to the expense trend analysis reported over 5 years, 2011 to 2015, it shows a moderate increase in judicial administration expenses of approximately 14%, while the Director of Public Prosecutions expenses increased by almost 11%. Whilst we anticipate if certain factions get their way, we can see these expenses skyrocket in the not too distant future. I wonder if you can tell this committee what are the factors that have contributed to these increases in expenses over the last 5 years?
Crave your indulgence, sir.
Absolutely.
In discussion with the Chief Officer, she's asked that I take this question. The Chief Financial Officer, she's asked that I take this question as it is more intimately related to the day-to-day running of the organization. Whilst I was not here, I can say for the entire period, I can say that there are certain features of the entity budget that has been going up over the years, and there are specific reasons why. One of the issues is the cost of security. Earlier, particularly around 2012 and before in 2013, judicial administration had a cadre of auxiliary officers supplied by the RCIPS. And these were police officers that supported the court in its security role. I would like to say around 2014-15, a transition occurred where the RCIPS expressed that they were unable to continue this service because they themselves were in need of the posts, the monies that funded those posts, and there was a transition of judicial administration having to hire private security services to fulfill a number of different security functions in the court. So that I can say is an area that has caused an increase over the years in the judicial administration entity budget. And it is certainly as a business of the courts increase and the need for additional courtrooms increase, that cost will increase in correspondence to those needs. There have been some staffing increases, and then there have been increases in the use, for example, of interpreters. These are services to the court, but certainly in terms of the rights of the individual in attending court, there are services the court must provide. If they are not entirely comfortable with the English language, it is important that they understand the charges that are being put to them and the case of the prosecution. So there have been instances where interpreters of different languages are used in the courts on the day, and if necessary, if matters go to trial, then there's a requirement of translation of documents, and those costs vary from year to year. There have been additional courtrooms that have come on board, and those are capital, I suppose, expansion of offices, but they are a hybrid between capital expenditure and entity expenditure, for example, utilities and so forth. So when courtroom 7, our newest courtroom, was established, we would have to increase the budget to allow for additional janitorial and utilities services, and certainly that will follow through or continue for any additional space that is leased over time. In addition to the one-off capital expenditure, there'll always be the ongoing entity expenditure to cover these costs on an annual basis. So it's a myriad of factors that have contributed to the periodic increase of the budget. You're welcome.
So just on the same trend, and this is just following on my colleague from the District of Prospect. I noticed on page 18, pension costs. I'm looking at, which is note 11. On the prior year was 2.889 million, and the total pension expense was 148,000. Yet, despite salaries going up 3 to 3.155 million, the pension costs actually went down. So I'm trying to figure out what's driving the decrease, because normally as the staff costs go up, the pension costs would go up, but it actually decreased. So I'm just curious as to what was driving that. And I noticed on note 16, on page, which is page 20, it said in terms of employee entitlements, it said the 53,000 decrease in employee entitlements to budget is a direct result of management efforts to reduce this liability. I'm curious as to what those efforts were, but I wouldn't expect pension to be reduced.
Through you, Mr. Chairman, with respect to the reasons regarding the employee entitlements, I actually find it hard to give you an honest and accurate answer. I think that would have been that would be personal to the last court administrator, who would have known the circumstances of his organization at the time and the reasons why he felt there was an opportunity for him to reduce liability through natural attrition of staff, etc. With respect to the reduction of pension and the salary, and then they have the salaries as a separate figure, not reducing, I cannot give a specific reason, save for that I do know there were occasions when temporary staff were hired to perform specific functions in judicial administration for specific periods on a number of budget years. And because they are temporary, that means that they would not be paid pension directly by the organization. We would pay a fee to their the agency that they are hired through. And that is perhaps the only feasible explanation I can give for the reduction of pension payments, and potentially also the fact that perhaps some posts were not filled. So perhaps the monies for salaries were used to pay for support, but then there was no pension liability directly by the organization at that time. Thank you.
You have for lease of property and equipment, can you break that out for me as to what your actual lease cost is for fiscal facilities? Where you mentioned earlier that you were leasing some spaces, what you're paying for that other than the government building?
Right. Thank you, Mr. Chairman. The primary lease space has always been the Kirk House building. That is a building that comprises 4 floors, and judicial administration leases the entire building save for one small office space that is being leased by a private company. The figure that I see here of 575 generally corresponds with what I understand the annual lease payment to be, the rental. There is one storage facility that we rent off-site. Yeah. But this figure largely looks like it is the leased property. The term non-cancelable is not a term that I'm familiar with, but I can say that the leases Judicial holds, particularly for its court accommodation, are for 5 years. Those contracts are negotiated through the Lands and Survey entity. I would expect that they should have some means for the government to exit the arrangement. But I'm not sure why. I'm not familiar with this term, and I would have to look at the lease itself to see if they are in fact non-cancelable.
Bush?
On page 17, Judicial Administration Report. Why is the cost of the website $317,000?
Crave your indulgence.
Sorry, $396,000.
Through you, Mr. Chairman, the website is maintained by BRAC Informatics.
Who?
BRAC Informatics, and which is a local company. And in addition to providing hosting services, there is a subscription section to the site, which allows for third-party users to subscribe to access the court lists, the laws, the judgments, etc., to the site. So that would, I really cannot say for this particular year if that is the entire cost, but this is June 2016. I do know in that particular year they did have a review of the website in addition to the regular service, but those are the scope of services provided by the website provider.
Does that include, is that also include your secure backup storage?
No.
That's
No.
Okay. My next set of questions, ma'am, is I'll preempt it by the case that I brought to the radio waves at the time when you had a 4-year-old girl molested by a 65-year-old man, and it took 3 years to get to the courts. By that time, the child could remember nothing, and the man went free. And I know, but that's why I'm preempting my question. Can you, as the chief officer for this thing, give me an idea? Just say Grand Court, 2010 to 2017. 2015 to 2017, your choice. What's the amount of pending cases?
Through you, Mr. Chairman, I cannot give the specific figure, but it is something that is information I can obtain for you. I do recall, my memory is not as good as it used to be, but I do recall the Honorable Chief Justice discussing the amount of pending indictments in the Grand Court, and if I am not correct and subject to correction, I believe he said it was about 100.
Correct.
And he did give a number of reasons why the delay. The delays are multifaceted, but I will say that there was a report conducted by Ms. Claire Wetton at the time to look at the state of our justice system and the improvements, particularly in the criminal area, that could be made. And I can say that there have a number of the recommendations that were recommended were implemented at the time. The issue of delay continues to be an area of concern for the courts in particular, insofar as I can say that we do have one primary judge locally who sits probably 90% in the Grand Court criminal courts. We have 3 permanent magistrates and 4 acting magistrates that sit in the summary court, and their portfolio is largely criminal. And we do bring in a roster of acting judges who primarily sit in the criminal high grand court to facilitate the speedy bringing on of cases and sentences, etc. And we do have another acting grand court judge locally that came on in July last year, who is helping to support the judiciary in the management of the criminal and civil cases. The primary obstacle facing the court is space.
Okay, Miss, I didn't even bother to ask you about the pending cases in the summary court, because I didn't want what you just gave me on the shorter version, which is the grand court, because the summary court is 4 times worse than what it is at the grand court level. Caymanians are suffering because of this. Lives are being held in limbo, and various different things that affect them in these cases. You're well versed in this, ma'am. Is it lack of money, lack of staff, or just lack of space?
Well, certainly lack of staff and space will be hand in hand, because it takes a team of persons to run a court. The primary driver is space at the moment, because just to shed some light on how the courts work, if the Court of Appeal comes down, and they come down on average 3 times a year, and they come for 3 weeks of sitting, if they come down, that means a grand court is bumped out. And in turn, if a grand court is bumped, technically some summary court cases are also bumped, because we now have to take a new court in for that space. If the Chief Justice for the last 2 years has asked to run 2 grand court criminal judges courtrooms parallel to each other. So if that is the aim, then that means invariably that the summary court from time to time may have to come out, because when we have criminal grand court trials, they're invariably jury trials, and we only have 2 spaces in the organization that can facilitate jury trials. So the consequence of each court and the business of that court has a knock-on effect to other courts. And I will say that the court that perhaps will suffer most is a summary court, and that is a court that has the highest volume of cases. So there have been concerted efforts on our part, and we continue to work with the government to find a solution, an affordable solution moving forward, to allow the courts to efficiently and administer justice. But certainly staff will be a consequence, because if you have a judge, you must have a personal assistant to help with their preparation of their judgments, to help them manage their docket. There's also to be a court martial. A court cannot be held without a martial. And then certainly if the volumes increase, then there might be some impact on our registries. At present, it is being managed as well as it can. I do not think that we have terribly compromised the business of the court with these infractions, but it has reached a point where if we do not have some relief in the foreseeable future, then the quality will be affected. And certainly the customers, the clients, are the ones who will suffer the most.
Yes, ma'am, and that's mainly Caymanians, and especially the poorer Caymanians. Now, once again, I'll preempt my next thing with a simple story, a simple case of what happened, and you'll understand. And the reason I do this is because I want the listening public to understand, because a lot of times we as elected members get blamed for things, as you know, we have no say in the judicial system. We make the laws, you all enforce them. On my street, a little dog ran up and down for 2 years, unkempt, not taken care of. One of the neighbors took the dog in, had a big vet bill, all kinds of stuff, well over $2,000-3,000. The dog started to live in the house with them. They leave and go to Costa Rica. Takes the dog. Come home, the man is arrested at the airport. Why? Someone claims, say that they dog napped the dog. This is a true story, ma'am. The gentleman was locked up because it arrested him on a Friday evening, Saturday and most of Sunday at the prison. This is a law-abiding man. The police did not come and question any of us on the street to get the story straight. It goes on, the man had to pay bail, couldn't leave to go back to Costa Rica to his wife, and had to get lawyer money, and 7 or 8 weeks later, after they said they're taking him to court, there must be the DPP, said yes, you can take it to court. All of a sudden, it was kicked out. Now, that case opened my eyes and made me start to ask questions. And in 2011, the Attorney General moved the preliminary inquiry out of the courts. In your professional opinion now as the chief officer, why would you take out the preliminary inquiries that would have taken some of this load that's in there out? Is there any reasoning, particular reasoning you can see for that?
Through you, Mr. Chairman, I think before I can provide a response, I am not aware of the Attorney General removing preliminary inquiries out of the court.
But they were stopped in 2011, that's a fact.
What I do know is that they changed the process for them, and they used to do what we call long form, which is quite a lengthy process in the summary court, to what they have something called short form, which is an abridged version.
Okay.
But the scenario that you spoke of, I think, goes more to administration of justice at an earlier juncture before it reaches the court, the role of the RCIPS and the police officer, and certainly the function of the DPP's office. I can say that whilst the court must remain independent of those entities, there is we try to have a much better working relationship and collaboration. There are a number of boards. There is, for example, I think it's called a Criminal Justice Board that is led by the Chief Magistrate Hall, who we meet with the various government stakeholders on a monthly basis to talk about issues regarding probation, prison, RCIPS, and any problems that arise that would either adversely affect the administration of justice or that may help it. And we can, and that's an opportunity to problem solve. So there are better working relationships. One of the areas that possibly could be looked at is the areas of alternative sentencing. And I do know that other measures recently were looked at in terms of cautions that are outside the judicial system. So there are modern methods to administering justice in a I want to say efficient way, because it's not about efficiency, but in a way that does not necessarily have to bring the person to court for every single infraction.
And like I said, ma'am, and thank you for being so honest. Thank you. Like I said, when you compare a 4-year-old child being molested and nothing done, but a stray dog, you could call it, who someone just wanted to say that they had a Pomeranian, but the dog is on the street running up and down, I know someone going to jail for that for a weekend, and thousands of dollars in lawyer fees, something has to be done. And that leads me, ma'am, maybe to my next questions. I know both yourself and Ms. Banks are new. So you all are trying to straighten up, and I would say the mess that you all found there, regardless who doesn't want to say it or not. Has there been any surveys done to the cost of issuing arrest warrants for minor offenses, unpaid fines, arrest of people that are very minor things, so such as a recent case where the pregnant woman was dragged shoeless from her home for a couple of $100.
Be careful now.
And do you accept that the courts no longer imprison people for judgment deaths, but the government does? Are you aware of that?
Through you, Mr. Chairman, I unfortunately have partially hung up my attorney's hat.
Okay.
If there is a provision for a person to be detained and their liberty deprived, I would assume that it's a last resort for the court. That is
Okay.
not something that the court would use as a first option.
Yes, ma'am.
Because we are mindful that the right to liberty is a constitutional right, and there must be a very justified and proportionate reason to detain someone and to deprive them of their liberty.
Okay.
But in saying that, there will be circumstances where the court will have to exercise its judgment, and in some instances it would result in someone being detained. With respect to the cost of warrants and fines and so forth, there are some areas that we are looking at.
Thank you.
So, for example, with the respect to fines, particularly in the traffic court, there is live discussion between the courts and the RCIPS, and it will perhaps be more cemented this year, this budget year, when we can explore a way in which we can perhaps reduce the number of persons that are coming to court through the for traffic offenses. The system now is that you have a fine to pay, you default, you got to turn up to court. Given the strictures that we are experiencing, and in a modern society, that may not necessarily be an appropriate way forward, particularly when you look at population growth. So we are exploring alternative options, and to see whether that can be implemented, where we can perhaps introduce a more incremental fine system, and it's only at a certain stage that somebody is then brought to court. With respect to the warrants, however, I will say that that if, depending on the case, if it's a warrant because of default of a fine, well, that will have to be a policy decision to discuss, how can we address that in an alternative way. If it is because of a safety reason, the warrants will continue to be issued.
Okay.
But the fine warrants is something that I cannot say that we have had that on our agenda as something that to look at, but now that you have brought it to our attention, it is perhaps something we can discuss with the Honorable Chief Justice and even perhaps the Honorable Attorney General to explore whether there are any other alternative methods to dealing with this issue.
Okay, thank you. And I see in the 2009 Constitution where the judges have a defined retirement age, but not the AG or the DPP. Why is that? And if that has changed, what is the retirement age? Please, I mean.
So through you, Mr. Chairman, I really don't think I can respond to those questions.
Okay, no
Sorry.
problem.
Thank
no
you.
problem. Thank
sir.
you, ma'am.
Thank
And my last one, is this your jurisdiction as well? I now have sitting 3 constituents, all indigenous Caymanians, married expats. They've gone to court for issues. The expats are making more money than the locals. The expats have gone to get help for lawyers, legal aid. The 3 Caymanians have all applied for legal aid who are making much less money, and they can't get legal aid. Why is that? Why is the person making more money, an expat at that, and of the 3, I think one has residency because they've only been married 4 or 5 years, 6 years. The other two just been married 2 or 3 years. So why is it that the local people can't get the aid, but the foreign people can? Is there an explanation for that?
Through you, Mr. Chairman, I would say that the decision of granting or refusing legal aid is based on the decision of the person who has the authority to do so. There are certain specific factors they look at. I can say that legal aid is not necessarily a straightforward process. Persons can be granted a certain amount with a cap, and there's an expectation that the case is concluded in that cap. There
Correct,
may be...
correct. 1 second, Mr.
Yes.
Clark. No, you're right. But the cap and all that is understandable. But if one person is allowed legal aid for case A, shouldn't the other person also be allowed legal aid for the same case A? What's good for the goose is good for the gander. The precedent is not the big thing in your law, in your circles.
The grant of legal aid is means tested, and it's based on the case. And it's also based on the information that's disclosed to the legal aid director, which was only recently appointed, so I have no idea how old these cases are.
Yes, ma'am.
But I can say that under the present system, and even in the past system is means tested, I can say now it is perhaps much more stringent, because we have someone and her team who are dedicated to looking at the expenditure of the legal aid fund. What could happen, and I'm not saying this is what is happening in these cases, is that there may be instances where some income is not disclosed to the director. And so whilst a spouse is of the view that this person earns X amount, that may not be the information coming to the director.
In all 3 cases, ma'am, they had copies of their spouse's checks.
Well, I cannot speak to it.
Right, you cannot discuss
I mean,
it, right.
the director has her
Okay.
decision.
Yes, ma'am.
And if they are unhappy with it, they can apply for reconsideration. There is a process under the law for them to apply for reconsideration of the decision. And I think there's a process for them to appeal to a judge if they're still not happy with the reconsidered decision of the director. So I really cannot delve into the decision making of the post holder.
Yes, ma'am.
But I can say that the legal aid fund is being managed, and I work very closely with the director because she is new, and I feel that the direction that she is going in is a very good one for the country. It is a good one for our budget, and we are actually seeing what I feel to be a more intimate review of the expenditure of the fund, and to ensure that we keep within the limits of the budget that has been afforded to by the government for legal aid.
I do appreciate you trying to be as forthright as possible.
Thank you so
very
much,
much,
sir.
ma'am.
Bye-bye.
Appreciate it. Thank you, Mr. Chairman.
Mr. Chairman, through you, if I may, add a brief follow-up to my colleague's questions moments ago. My next question relates to managing future expenses relevant to the desire for a new courthouse. I also believe this stated need has bearing on existing expenses downstream relevant to lease space, increased security needs, etc., as has already been mentioned in the current period. I am also trying, for the avoidance of doubt, to try to reconcile in my own mind the case both for and against the need for new court facilities. During the opening of the Grand Court, 2018, the Chief Justice accused the government of failing to understand the constitutional crisis in the justice system and the urgent need for a new courthouse. He once again argued that space had reached a premium and that current facilities cannot accommodate the number of cases coming before the courts. This, of course, has a correlation to the expenses of the judicial administration in the short term, as has been clearly stated in the testimony. On the point that my colleague, I believe my colleague Mr. Bush was referring to, in 2011, a lone local attorney, Peter Pollock, made the case that the present situation of lack of courtroom space comes down to a number of factors, most notably the removal of the preliminary inquiries in the summary court, as my colleague mentioned. I believe, and again going from memory from media reports, he argued that preliminary inquiries, which are still used across most of the Caribbean region, enabled many cases destined for the Grand Court to be removed, often by a single hearing, sometimes by depositions only, for matters that failed to reach the prima facie benchmark. He argued that the removal of the preliminary inquiries caused the immediate consignment of the most serious criminal cases to the Grand Court, which was unprepared to receive the tidal wave of hundreds of cases requiring vast resources. He argued that there was no committee review, there was no peer review, no stakeholder consultation that would provide empirical analysis to support the removal of the preliminary inquiry and its multifaceted effects downstream, which has led to the demand for a $200 million courthouse that the government argues the country cannot afford. My question to Ms. Bothwell is, do you agree with these assertions from Mr. Pollock? And if not, please tell this committee where, perhaps in your opinion, he may have erred.
Through you, Mr. Chairman, before I commence to respond to your question, there was never a proposal by the Judicial Administration for a $200 million courthouse. And I do not intend, unless instructed to do so, to go into the details of the discussions between Judicial Administration and the government. However, I can say that there was a particular figure that was less than 100 million, quite a bit less, significantly less, for us to commence a two-phase project. I am aware of the media reports on the various discussions that have been had after the Chief Justice's speech. All I will say is that Judicial Administration will be engaging with the Office of the Premier and the government about how we can restart discussions about upgrading the existing court facilities. The issue of what solves the problem of delay in our court, or what has happened that has caused further delay, I think would require much more exploration for me to give a proper response today. The PI process is a very specific process in the criminal court. It is one facet of the criminal process, particularly that relates to the more serious crimes that are committed. Not every charge is subject to a preliminary inquiry, only those that are to be moved up to the Grand Court. What we are seeing is delay in the Grand Court. We have 100 indictments pending, but I cannot say that the preliminary inquiry process is the sole cause of that. I believe, from what I said earlier, it is a much more complex and faceted issue that regards the whole workings of the court and the knock-on effects of how we sit, what courts sit when, and the type of cases that we have. I do not think there is any doubt that the current facilities that we have are inadequate. They were deemed inadequate from the 1990s, and there have been a number of courthouse projects over the decades to find a solution for the courts. I do not believe it was anticipated by those who constructed the main court building that we would seek to rent a commercial space next door to substitute it as a courthouse. We rented a commercial space that was never built to be a courthouse, and a courthouse cannot simply be dumped into a Class A commercial building. The needs of courtrooms are very different. Whilst one can retrofit a space to accommodate a court, it is not necessary that you can just identify a complex and you say that is your courthouse. And that has been part of the problem. If one considers it, the court is split in two. So I have to, as chief officer, assess how I manage two separate complexes to manage one organization. An organization that tends to interface with two buildings. There are many risk factors in having a separate complex. I can say that the security costs are perhaps disproportionately high because we have two separate complexes to manage the courts, and we have our business on separate floors, and the floors are not built in such a way for us to integrate security into the layout of the building. And that is only one feature. So I will find it very difficult, and I certainly am not prepared to talk about the full gamut of reasons as to why there is or there is not a need for better or improved court facilities, or whether or not and to what amount of money should be spent by the government. But I can say, upon me coming into the organization, my estimation is the need is dire. The need is dire, and I am optimistic that with the government we will find an appropriate and affordable solution. Because if we do not, I feel very strongly as someone who has practiced law in this jurisdiction. I am from here. I believe in the justice system and democracy, that judicial administration and then the support of the judiciary can, if it's not run well, it can help collapse the democracy. So I must be optimistic that we will find a workable solution to the problem. We will do our best, and we will continue to engage with the government. And certainly I do believe that the issues that have been raised by Mr. Polak were valid issues, but I cannot say they are singular issues to the reason for the delays. The courts is made up of many, many different facets. We have the criminal courts, which I will admit is our largest division, but our financial services division is extremely heavy division. Our civil and family is huge. And then we also have the maintenance of the families. And I will say, if any of you, I make an open invitation, wish to visit the court, I will be happy to give you a tour, particularly on a Friday, when it's our family maintenance day. Because I will say to you, it is horrifying sometimes to see the conditions that our clients have to come in, and it's also a safety hazard because of the sheer volumes that have to come in to the courts to deal with their maintenance. So as I said, I'm optimistic, and it's a new year. I think that there's been a lot of ventilation of issues, and certainly it is now time for us to come back to the table, and I have received confirmation that that will happen sooner rather than later by the government, so that we can have productive discussion as to how we can move the initiative forward in a way that meets the needs of the country. Thank you, sir.
Mr. Chairman, thank you very much. Just a point of order. I did not state that the removal of the preliminary inquiries was the primary reason for the need for a new courthouse, but it was one of many factors, most notably the need for preliminary inquiries. I just want the record to reflect that. Secondly, obviously I'm no lawyer, nor am I involved in the judicial process in any way. And the purposes of these questions are just to enable me to better understand, as I stated prior, the case both for and against a new courthouse. It is clear from an individual who operates in that realm on a day-to-day basis what your viewpoint is on that subject, and I appreciate it. I appreciate your honesty. But likewise, as a member of the government, whether it's $100 million or $200 million, somebody has to find that money. So it is a matter for a future expense. And as I have stated previously, I would certainly encourage the Auditor General's office to consider a special report on the subject of a need for a new courthouse, because I believe it is important for the country to understand the economics based on the pending need. And as the Chief Officer has rightly stated, we certainly don't want to create a crisis for democracy based on the absence of courtroom space. But if I may take the question one step further in the recommendations, again, coming from one who either currently or otherwise spends his time in the courtroom. And again, I preface the fact that I am no lawyer, nor do I have any knowledge in this area, but I'm trying to understand it. Mr. Pollack went on to suggest 4 alternative options to address the issue of courtroom space other than a new court building. One of them was the introduction of the preliminary inquiry. The second was to constitute a review board to review all pending grand and summary court cases, with the oldest first. The appointment of a prosecution oversight committee to perform peer review and immediately stop borderline or inherently weak cases from tying up the court system. And he also recommended the implementation of the recent UK Justice Review Report on the Office of Director of Public Prosecutions. Now again, I wonder if you would share your thoughts on these recommendations. Do you believe they have value, and could they represent an alternative, or do you take a different view?
Through you, Mr. Chairman, I would have to actually read the various materials in order to make an assessment. And I think that's first and foremost. Certainly, anything that is outside of the court itself, I would have to be very, perhaps, limited in what I say, because that is not my jurisdiction. I have no oversight or control over those areas. The working of the DPP's office is an independent office constitutionally, so certainly it would be a matter for that post holder to determine what is most efficient to run his or her organization and to discharge their constitutional duties. Likewise, the Office of the Attorney General. With respect to, and that will, of course, that statement refers to the various recommendations that Mr. Pollack makes with respect to the prosecution, peer review, etc. With respect to the court itself, I would say that I am very open to discussing with third parties and through the Chief Justice, because ultimately he will have to assess the appropriateness of any recommendation to bring about greater efficiencies within the administration of justice. It is something that we are keen to continue to look at. I think administration of justice is a living thing. Every day, people come into court. Every day, laws are passed, creating new offenses or regulating matters that will end up in court. So the court must adapt to the times that it is in. So we do recognize that. However, we must be able to maintain our independence and to maintain the standards. But I do think that there is a lot that can be done in collaboration with various government entities who are what I consider our internal clients, to bring about efficiencies in the system. And I can say we are working at various levels to achieve that. An example is that we are updating our database to allow for electronic filing of documents on the civil and criminal side. So you will be able to see, particularly in this year, you will see civil filings being scanned in and emailed into the courts, people being able to pay electronically as opposed to having to come until 3 o'clock. We will have the entities that provide reports to be able to email them into the courts as opposed to them having to walk them over and when the registries are over. And certainly on the criminal side, which is our largest division, we are looking to bring about greater efficiencies with respect to the processes. But certainly that is perhaps only part of the picture. The more fundamental part, I think, is looking at the substantive issue and to see whether we can do it better. Right now, I know the prison is under a lot of pressure with the remands and the well, the remands in particular, I think, is the biggest issue for them. And, you know, perhaps a revisiting of the alternative to sentencing legislation and the putting into force those provisions will give the courts greater flexibility to discharge its duties when it is sentencing individuals. It's not just about going to Northward or Fairbanks Prison. There are many, many options out there, but until those are ratified and enforced, the court's options are limited. So there is room for discussion in terms of how we can make things more efficient, more relevant to today's society, and to bring about more greater justice and reduce delays.
Has any consideration been given to holding court in the later evenings, at night, and on weekends, since space is the primary problem?
It has, Mr. Chairman, that issue has been raised. It will require me to have a whole second cadre of staff, because the staff right now are in court whole the entire day. So in order for us to actually have a night court, we would have to have an additional panel of judges or magistrates and a second team of people to manage, to administer that business.
For instance, you said earlier that if the appeal court takes up one courtroom, that'll kick a grand court out, which kicks a summary court out. Certainly those summary court staff would be available to meet in the evening if they're not having court that day.
It depends, because, well, they won't be in open court that day, but you might find, for example, that some of our magistrates are acting judges. So if they're out of summary court that day, they could then take on cases in the grand court for chamber matters. But theoretically, you may find that there is some flexibility in time, but I don't think that when they don't have court, they're not doing anything. Their time is filled with other aspects of court work.
Thank you, Mr. Chairman. Through you, sir. First of all, I want to thank the Chief Officer for our elaborate answer. It was quite informative, and I will accept our invitation for a tour. I've been fortunate that in 4 to 5 years I've had no reason to visit your facilities. But one of the things I am curious about, and this is an issue that affects some of my constituents, is the old deadbeat dads or the parents who are supposed to be paying in. Because many cases where there are these court orders for them to pay, then they start paying for a month or two, then they stop. And a lot of the single mothers are affected by some of these fathers who are not paying as they should to support. I'm curious in terms of the enforcement of those parents who have those obligations, especially to their children, to leave all of that on one parent. And then when you do see them on Facebook living it up, and the kids are basically suffering because they aren't doing what they're supposed to do. I'm curious as to what the process is or what the procedure is within the court system to deal with the enforcement of those judgments that once they've been made. Because some of those guys just need to be arrested.
Through you, Mr. Chairman, the issue of maintenance is quite a complex and nuanced issue because you are dealing with the family. And certainly, the non-payment of the maintenance has a very real and tangible impact on the child or children, to the point where they can experience levels of poverty in the home. The court, I believe, tries to understand that it is dealing with human beings and it's dealing with families, and families number one. So if there is a circumstance, and I think the court gives great latitude to give the person who is in breach an opportunity to pay and to make up any arrears. When they're in jail, they can't pay the arrears, they're not working. So if there is an opportunity to give them time to honor their obligations and pay their arrears, they will try to work with them. We have implemented a mediation in the courts for family cases, And it is still very new, but it is to understand that it is a means by which we can bring the conflict resolution out of the courtroom, whereby the parties themselves can perhaps negotiate some of the solutions. In the most extreme cases, the persons will be sent to jail. I'm aware they will have orders to be imprisoned for failure. I cannot say what the statistics are on an annual basis for that, but certainly it does come back to impact the prison itself, who is bursting at the seams for persons who are in there for imprisonment and remand. So that is also a concern. Not a primary concern of the court. If it is justified, the court will make the order to imprison, and the prison does have to find the facilities to put the persons in. But I think this issue, the courts can only do so much. I think this issue goes much deeper than the courtroom and the courthouse. This is about the social fabric of our country and our people, and their commitment to parent their children. The reality is that those who are in court for 18 years with the children. If they cannot find an amicable solution and honor their commitment to pay the maintenance, then they will be in court for 18 years fighting over the maintenance of that child. And that is, because that is the obligation. A child is a child until they're 18 years old, unless they go to university and the orders may extend to 23. So if parents cannot find a way to parent together and to honor their obligations, they will be in court, if not on a monthly basis, multiple times every single year for 18 years. And that is why I say the courtroom solution, the maintenance regime only addresses part of the problem, and the court can only do so much.
Sir, Mr. Chairman, through you, sir, as a follow-up, I think the challenge that raises in our society is that we settle disputes within the courts. And once a court has made a ruling on a dispute, we expect as a society for those rulings to be carried out. And the minute we start subjecting those rulings to what someone feels or what someone's this or what someone that, then that is where there is also a breakdown within society. Because at the end of the day, we're still a society of laws, we're still a society of rules, and a judgment has been made. And at the end of the day, there must be consequences. If a judgment is made within the court and it is not carried out, there must be consequences, whether it's contempt of court or something else, because what you start having now is when you're seeing these kind of things happen where people feel that they can't get any justice, that is when they start taking the laws into their own hands. And I can tell you, for the single mothers that be calling me, for the single mothers that are struggling, and for the fathers, and what really bothers me is the gall of some of these deadbeat dads to not be doing their jobs, and then have the gall and the audacity and the temerity to be on Facebook with the biggest of flossing that you can see, and not taking care of their children when they should be locked up. I'm going to tell you straight up, it does a disservice to the court system. Because at the end of the day, a judgment was made for them to do X. And if you're not doing X in our society, it must be followed by a Y. But it can't be where you're defying the court openly and you're not being sanctioned. It's not a way to build any society, because the court is still the final place for us to settle those disputes.
And through you, Mr. Chairman, I completely endorse the concern that you've raised, and it's not that the court is turning a blind eye. I think part and parcel of it is the system that we have. Cayman is not a jurisdiction whereby if you are employed, your income is registered. There is no central database by which a magistrate can go to say, well, Ms. John Brown, I can see that you say you're not employed, but I can see from the system that you have been employed and this was your income. So a lot of the information is reliant on what the offending parent says to the court, unless the court can verify independently that information. If the spouse or the former partner comes forward and says, well, I know he was employed ABC, then there are instances where the court may subpoena those records from the employer. But that requires a certain level of due diligence by people who are not the court. So unless Cayman obtains the infrastructure to allow for greater transparency regarding people's income, then certainly the court will continue to struggle with enforcing the orders that it makes. No court is going to allow a defendant or an offending party to flout any order it makes, but it is about being able to properly have the information and the evidence to verify, particularly in the case of maintenance income. I have worked in child protection for many years, and I can say, and I'm sure the mothers can speak to you about all of the steps they are taking to directly avoid the payment of maintenance by certain persons.
Maybe the sentence should include a work program during the day, jail at night, you work at the garbage, not picking up garbage during the day, and instead of paying the person, you pay the parent.
Lock one of them up. Just one. Lock one up.
They have been up until 2 weeks ago. I think they almost broke into my office because he was locked up for not paying maintenance.
Mr. Chairman.
But I will say that I think it's something that may have to be looked at in the round to see how we can have a holistic system to support the courts in being able to enforce this particular issue.
Mr. Chairman, through you, I said I'd finished, but your answer just now, I thought I was talking to a social worker. My esteemed friend here from Bordentown put it most eloquently. And beside those that are fronting on, you even have some who are not even Caymanian. And they think you breed a local, you get the points to stay here. Or they can't ship me off because I have a child. NAU, you're talking about a prison loaded with them? Go to check out what poor NAU is going through, having to support children from deadbeat fathers. But once again, my partner here just said it straight. Make an example of a half a dozen of them. But I have, just since you said that, I WhatsApped 5 different people who have come to me. One of them is owed $36,000. The father is walking up and down here, smoking cigarettes, and at one time quit his job so he wouldn't have to pay. So since you don't want to work, go northward and do something. So maybe like what the chairman just said, ma'am, maybe it's time to sit with the judicial people and say, part of that punishment is when you go to northward, you're going to come out and sometime work up that dump or something to get money to pay these children. If we're going to pay them through NAU because you all, the judicial system is not, you're getting it in another way, but as representatives of the people, we're getting it, and I'm telling you, I'm paying it out of my pocket, which I don't mind, because at the end there's young Caymanian children. But they are laughing when they're told to do this, and they're getting no punishment. Oh, we're going to review this, review that. It's almost bad as the fireman's salary. Been reviewed for 6 years and nothing done. Thank you.
Ms. Bush. Thank you much. Thank you very much.
But that completes our hearing for today. So we'll have lunch and then be back here at 10 o'clock tomorrow morning.